Hello, I'm Bob Weeks for Wichita Liberty TV, your weekly source for news, analysis, and commentary about Wichita and Kansas government and public affairs. Broadcast on Great Plains Television, that's channel 26.1. Our big times are Sunday morning at 8:30 and again at 4:30 in the afternoon, although we have some additional times on Sunday and also Saturday as well. You can find all that at wichitaliberty.org, my website. You'll find show notes for today's episodes, all the old episodes, and all the other material that I and others create almost every day. So today our guest is Richard Peckham, who's an attorney in South Central Kansas, Andover in particular, I believe it is. He was a Republican candidate for governor in 1990 and has been active in writing to the Wichita Eagle and other areas about the opinions of the Kansas judiciary, especially the Supreme Court, what's going on there, how judges are selected, something that a lot of people are not real conversant with. So let's dig into some of those issues. And Richard, last year there was a case, and I don't even want to talk about what the issue was because it is a divisive issue, but the United States Supreme Court overturned the Kansas Supreme Court by a vote of 8-0, and the other justice said, I can't remember what she said, but she didn't disagree with her brethren, I think. And a couple years ago, there was a case where upon appeal to the Kansas Supreme Court, they overturned the Kansas Supreme Court 9-0. Now we're told that the way these judges are selected is a merit system, but whatever the issue is, it seems that the judges are having some trouble complying with what at least the United States Supreme Court says the law is.
Well, absolutely, Bob. The system that we have right now to select Supreme Court justices is horribly flawed. Mm-hmm. The governor makes the selection, and whether it's a Republican or a Democrat, it's still a highly politicized process. And so there are two methods we could go to change that. Mm-hmm. Number one is direct election by the Kansas population, which I would favor. The second method would be to have the governor select, as he does now, but subject to the advice and consent of the Senate. One of those two would be infinitely better than what we have now.
So the second method is almost identical to the way federal judges are selected. The president, be it Barack Obama, Donald Trump, chooses, and the Senate either confirms or rejects. But how do we do it in Kansas at the moment? You said the governor selects, but who does he get to select from?
There is a selection committee that the statute puts in place that sends the governor three options. So he's locked into those three options. Mm-hmm. So whatever the constitution of that committee, their political constitution affects the three that wind up in front of him. He may not like any of them. He may like a number of them. It's hard to tell. But he makes the final selection, and the process is pretty well hidden, mm-hmm. both in the committee and by the governor until it's announced. Mm-hmm. The system ought to be open so that the people and the press have an opportunity to vet these people, to question them, and in either of the two alternate systems for selection, you have that opportunity.
And I know a problem that some people, like Stephen Ware, professor at the University of Kansas School of Law, who's written a lot about judicial selection, he says the problem with the Kansas system and what makes it at the extreme of all the 50 states is that nominating commission, a majority of them, of the members, are chosen by members of the bar. And I'm not talking about the neighborhood bar, Karl, where you stop by after work. We're talking about the lawyers, yes. In Kansas, and they effectively have a majority on that, and that's led to perhaps selecting of justices that a lot of Kansas might not agree with.
Well, exactly, and you have a political milieu within the bar, and you have relationships between the nominating committee, between lawyers and judges that are practicing at both the district court level and the appeals court level. Mm-hmm. So the political element enters into that process at that point. So you don't have much input from the public at large. It shouldn't be all lawyers making the decision about who winds up on the bench, in my opinion.
Well, aren't we in a situation where, since a majority of the 9-member commission, 5 of the 9, are coming from the Kansas bar, the 4 who are appointed by the governor are representing basically everyone else. And so really, if you're not a lawyer in Kansas, you're a second-class citizen at the state level when it comes to judicial selection on appellate court judges.
Yeah, absolutely. Carl and I've talked with some of those lay people in that section of 4 about what the process was like when they got together for those nomination hearings, and they acknowledged the lawyers control it all.
I can just imagine, well, some of the op-eds that lawyers and judges have submitted to the Wichita Eagle on this topic, it's clear that they think only lawyers are able to determine who is qualified and who is not qualified to be a judge in Kansas. And to be clear, we are talking about just judges at our appeals court and Supreme Court, although the appeals court has changed. We'll talk about that after our break. But the courts that are like at your county courthouse, those are chosen in yet a different way. So let's take a moment off for our first commercial break here at Wichita Liberty TV. When we come back, we'll ask Richard Peckham more about how judges are selected in Kansas. Well, welcome back to Wichita Liberty TV. I'm Bob Weeks. We've got co-host Karl Peterjohn, our special guest attorney Richard Peckham, talking about Kansas judicial selection, just issues with our legal system today. So there has been a change in recent years how judges at the Court of Appeals are selected. How does that work now?
Well, now you've got the population, the people participating in the process and making a selection in a popular vote.
Mm-hmm.
Now that could be done without changing the Constitution, and it was done. However, to go the next step and get the Supreme Court selected under the same process, you need an amendment to the Constitution. That's a little bit bigger hurdle.
In Kansas, if I remember, that requires 2/3 of each the Kansas House and Kansas Senate to agree to a resolution. Governor doesn't really participate except on a leadership level, I guess, but then that resolution is put to a majority vote of the people of the state of Kansas.
Yes, yes.
We don't have very many because that's a constitutional amendment, because that's a pretty high bar to overcome.
Well, the 2/3 in both houses doesn't occur real frequently. It has on a few occasions. But when it comes to judicial selection, why is it so different between the district court levels, depending upon what county you live in, and the appellate courts in Kansas?
Well, Karl, each individual district has had the opportunity to vote as to which system they wanted. So you've got the northeast part of Kansas, and those counties and those areas, they stick pretty much to the governor's selection process. And the western and some of the southern areas, so it's split roughly half and half, but the people made that decision. But again,
when did this occur? Because it hasn't occurred since I've lived here, and I've been here since the 70s.
This happened quite a few years or decades ago. I don't remember exactly when it occurred. But there's tension then between the judges that are selected by the governor, and they throw rocks at the judges that are selected by the people by popular vote. They think that that's a dirty political process, which it's just the reverse. The people participate, whereas a very small group in a back room influence the governor to make.
But we have a system where anyone could be appointed to the U.S. Supreme Court. There's no requirement to be a federal judge that you have to be a member of the bar.
Right. In Kansas, you've got a fairly closed system. The end result is you get a Supreme Court that becomes arrogant over time. They know that it's pretty hard to get rid of them. They know that people don't know the process. And so when someone begins to campaign to try to show this is where they're wrong, we need to remove these, the people don't know. They don't have the experience in it. But the arrogance is what came through. And in the two cases you mentioned, where the U.S. Supreme Court banged him on the beak pretty solidly.
Yeah.
Both of those were death penalty cases. And this Kansas Supreme Court arrogantly put forward positions that had been knocked down by the U.S. Supreme Court in other cases decades earlier.
Or did they hope no one would notice?
Apparently, there's an arrogance in there that says we want what we want. So you've got the majority of the Kansas Supreme Court justices who are making decisions not based on the Kansas or the U.S. Constitution, but based on their own political predilection, adoption, or there's abortion, death penalty, all those, it comes through so obvious, and they're willing to go ahead when they know they can't win at the U.S. Supreme Court, and they do it anyway. There's arrogance.
Yeah, and when these, the district court judges, we know down here in Sedgwick County, the judges have to stand for election every 4 years. Let's say like in Johnson County, our state's most populous county, if the governor appoints a judge, is that subject to Senate confirmation or just the will of the governor?
They go through a retention vote process.
Okay, up there, okay.
Yes.
And that's similar, I think, to what the justices on the Kansas Supreme Court do every 6 years.
Yes.
But no one has ever failed to be retained, is that right? Now, last year, there were, some disappointment with some of the judges, and it got pretty close. I think some of them just got like 55% of the majority they needed, but there was some active.
And since 2014, all the retention elections have been well under 55%, and some were fairly close, 53. But in terms of retention elections, I believe a couple district court judges have not been retained at one point. But
right.
but in terms of appellate court judges, since we've had this system for about half a century, they've always been retained, and none of them have ever lost their position, as I recall. And the studies I've seen, I think Stephen Ware had looked at that too. But
And I think, as you mentioned, Richard, earlier, that people are just not aware of this. Like they call your office and say, should I vote yes or no? Or
Every year I get those calls. They say, I know nothing about the district court, much less the Court of Appeals, or who's for retention at the higher court, and that they ask for recommendations. And attorneys are asked that question all over the state because people don't go into courts for the most part. Most of them don't kill people. And they don't. Most of them aren't involved in
Commit
civil
crimes,
actions either.
yeah.
So they don't know, and they rely on other people to make those decisions. Sometimes they don't even vote on that part of the ballot because they don't know anything, and you can't blame them.
yeah, absolutely. I know oftentimes I just leave the judges blank because even though I kind of know who these people are, a lot of them, because I pay more attention than most people do, it's down here, so many of them are unopposed in the general election that, why even bother touching the screen? So
One of the major problems is that for a long time, judges have not been able to speak their opinions on issues. Any other candidate for county commission, wherever, they're out there talking to the people, talking about the issues. But they set up an ethics requirement that said basically you can't talk or we'll gig you if you do. So that left all the judges in the state fearful of saying anything except name, rank, and serial number. So we went to court and got that changed. We filed against the Supreme Court.
I think this is the Stout case. Is that the name of it?
Yes, we filed against the Commission on Judicial Qualifications in the Supreme Court. We said this is a violation of the First Amendment rights, not only of the judges who might want to speak and give opinions, but the right of the people to hear and understand what the opinions are. So nobody has any information going into any of these elections. It's just absolutely, I call it the mushroom farm. Everything is done in a dark environment.
Okay, that's pretty good. Well, we've got to take another break here. So in a moment, we're going to come right back with Richard Peckham. I'm Bob Weeks. Well, welcome back to Wichita Liberty TV. I'm Bob Weeks with our co-host Karl, Peterjohn, and Richard Peckham as our guest this week. And we're talking about Kansas courts and judicial selection. There was an op-ed in the Wichita Eagle last year that said, we don't need politicians as judges. This was written by a judge, no surprise there. But Stephen Ware, again, the KU law professor, he's talked about how, first of all, at the level of the appeals court, the case is there because there's a question of how to apply and interpret a law. Is that right?
That's right.
And there's a conservative and a progressive way usually at looking at those questions. I mean, a progressive way would expand the power of government in some way. Conservative would reduce that power. Not every issue might classify that easily. But it is, judges are making law in a sense that is going to be on the books for years and years potentially. We know that's why cases are fought so hard over at the United States Supreme Court. So why shouldn't we know a little bit about the political philosophy, the temperament of the people that are going to be our judges?
Oh, it's just really important, not only at the state level, but down up at the federal level as well, that people have a full vetting of everything.
Mm-hmm.
And because there's huge issues that are at stake. The U.S. Supreme Court, as you know, is about to make a decision on whether you can be forced to make a cake as a baker
Mm-hmm.
for LGBT people, and the cake advance the interest of the LGBT philosophy,
Mm-hmm.
whether you should be forced to do that or not.
Mm-hmm.
Well, these are huge issues. The public isn't aware of the political quality of the people that are making these decisions all the way up.
Mhm.
And if you come through the circuit out in the Ninth Circuit in California, you get the wildest, strangest, non-constitutional decisions, and they're reversed more than 50% of the time
By the United States
by
Supreme
the United
Court.
States Supreme Court. So you need the public involved in this whole process a lot more in the selection process.
Mhm.
So you get qualified people who will follow the Constitution. The Constitution, both the federal and the state Constitution, is the document that the people hand to the judges. It isn't something that's foisted upon the people. They vote and prepare those documents, and they don't want the judges to edit them, change their meaning, and yet that's exactly what happens.
But here in
And the
Kansas,
cake, I'm sorry, the cake decision is of course important, but down here, as we've talked a lot about, Karl, we have dollars and cents issues like the school finance that's been winding its way through courts in various forms for 20 or
well,
however
now
many
we're well
years.
back into the 20th century. I mean,
And now we're
there
on
was
the-
a case out of Shawnee County I think in the early 1990s that made a major role. Judge Terry Bullock was involved in that, and we've got a situation where the Kansas Supreme Court seems to be the final word on the Kansas Constitution, although theoretically they've got to live under the federal constitutional boundaries, even though, in my view, they've often usurped the powers of the elected officials, and especially in the school finance area, Bob. But theoretically, theory and practice, that sometimes doesn't matter in the law.
Well, it does, and the really what this sets up is what we call a constitutional crisis. You've got three branches of government, which are clearly set out in both constitutions, and yet you've got one branch that decides they want to usurp the clearly stated right to term taxation, which belongs to the legislature.
Mm-hmm.
It does not belong to the high court. So that sets up a crisis. Does the legislature then turn around and say to the Supreme Court, you've erred, and we're not going to follow your edict?
Mm-hmm.
And not only that, you have the absurdity of the Kansas Supreme Court saying, well, then if you're not going to comply with us, we're going to shut down the Kansas schools. Now, how absurd is that?
And I think there's a move in the legislature to perhaps have a constitutional amendment that would prevent the courts from closing down the schools. So when we come back from this break, I'd like to get your opinion on what happens this legislative session if either the legislature is not able to come to an agreement as what to do with school finance, or if the legislature simply says to the court, we think we're spending enough regardless of your opinion. What do we do now? We'll be back in a moment. Well, welcome back to our last segment of Wichita Liberty TV for this week. Bob Weeks here with co-host Karl Peterjohn, Richard Peckham, an attorney in Kansas. So I teased that the Supreme Court has told the state we need to do this. What if the legislature either can't do it or decides not to do it? What happens then?
Well, that would be a test of the of both the legislature and the high court. The high court does not have a gendarme, a set of agents that they can immediately go and say, we're going to close all the schools. They don't have that. All they can do is issue paper. The governor has the option to use the National Guard if necessary.
And the highway patrol, I thought too.
He has the option to tell the principals and the school boards, you will stay open. Now, there could be a fight there between the local school boards, but most of them are going to want to stay open. Education is extremely important to American, and Kansas certainly as well. So if you present an order that a retaliatory order from the Supreme Court says we're going to close your schools, mom and dad aren't going to be too happy about that.
Well, let's put this in a legal context. We've got an appointed court, we've got elected legislature and elected governor, and we're supposed to be, according to the U.S. Constitution, we're supposed to be a republic, specifically mentioned in Article 4 of the U.S. Constitution. If we've got a judicial oligarchy, which I think the Kansas Supreme Court's trying to behave in that way, making these edicts on basically power of the purse, tax and spending issues, haven't we moved away from being a democratic republic and putting ourselves in a position where we've got an appointed body setting over 50% of the state's general fund is K through 12 education funding, and we're on not only slippery legal ground, but slippery constitutional ground, aren't we, Dick?
Clear distortion of the system. But the question is, how far is the executive branch and the legislative branch willing to go? Are they going to continue to allow the Supreme Court to badger them outside the confines of the Constitution? Or will they stand up and say, no, this is an illegal order, it is improper, and we're not going to enforce it? And that's, in my opinion, the only way you get to some change. By the way, a byproduct could well be that the public gets involved and they begin to learn about the high court, why it is constituted the way it is, how you get good people, how you get bad people, where the politics come in. So there are both primary and secondary potential gains for the legislature to bow their backs and the governor to get behind them.
And schools definitely are an issue. Certainly parents, of course, are deeply interested in schools, but everybody should be. First of all, they cost a lot of money to run, but also as people like, when I get as old as Karl someday, then, we need young people to keep working and take care of us.
If you're lucky enough.
No, but yeah, education is, I don't think it should be so much a state function as it is. We should have, that's a problem in Kansas, we have very little opportunity for school choice, but we certainly have. And the other thing is, how can the Kansas Supreme Court really say this is unconstitutional, what the schools are doing? Can there really be that bright a line between this is constitutional funding of schools and this is not? And is the results the schools are producing, is that constitutionally adequate or not also?
The Kansas Supreme Court is not constituted, does not have the staff to be able to evaluate what's good education and what's bad. That's the prerogative of the legislature and the people. The people that are elected should make that decision. The court arrogantly takes on the position that says, we're going to make the decision ourselves. And as long as the other two branches cow to that decision, it'll continue. Because you've got an arrogant group of people at the high court, not subject to the people for the most part, because the people don't know when a retention vote comes along. We don't know. We just, and so they wind up continuing in place. That breeds arrogance because there's no accountability.
Now, there was a lot of talk, last year's retention re-elections. What was it about Karl that made those so notable and so much in the news compared to other years?
Well, because they had some cases overturned by the U.S. Supreme Court. I think the case that resonates strongest here in the Wichita area was obviously the car murders and the atrocities that were involved in that hideous murder cases. But the challenge, Bob, going forward is trying to have accountability and disclosure, because we've got a Chief Justice who has been disciplined for misconduct in the earlier school finance case under Montoy and continues to sit in these cases, even though he at one time had represented the lead plaintiff school district in this. And Dick, the question I'd throw out is, do we have an adequate system for monitoring judicial ethics when we've got so many flawed people on our top court?
The system, Karl, really is not adequate. The Commission on Judicial Qualifications is commissioned with the job of making sure that the justices follow the code of conduct for judges. But unless somebody files a complaint, they aren't sitting there scrutinizing everything that's done. They won't on their own motion jump in and make that. Someone has to come forward. Well, the attorneys don't come forward because they have to practice in front of these people. Mm-hmm. So it takes a courageous individual who usually is not an attorney to make a complaint about a Lawton Nuss.
Because even, well, having made a complaint, the process is completely non-transparent because basically
Yes.
there's a closed door meeting, and basically
The decision is not announced
the
to
decision
anybody.
is only announced to the person who makes the complaint.
Unless I think it rises to a certain level
Well,
of punishment.
Even if they're, well, in terms of the level of perhaps punishment, when I filed a complaint, I basically got a letter saying your complaint was heard and rejected, and that was it.
Yeah.
But what was amusing in a sort of sad sort of way was trying to explain this to the media, because the media could not get confirmation that anything had actually occurred.
Yeah.
I basically had to take copies of the letter that I received saying, here, this is what I received from the board, and if the media called and said, we want to find out what happened concerning the complaint that was issued by Mr. Peterjohn, they said, oh, we can't, we have no comment about anything coming before us.
Yeah.
It is a hidden system. I call it the mushroom farm. You raise mushrooms in the dark. And that's what happens with systems where there's no accountability. And when the bar controls everything and you've got the Supreme Court that feels arrogant that no one's going to touch them, they can't be hurt, so they become politicians first and justices second.
Well, I've got to cut in because we are out of time for this week. It's been a fascinating conversation, and I hope that we can continue up with this again. So, Richard Peckham, Karl Peterjohn, I'm Bob Weeks. We'll see you again next week.